All right. Welcome, everybody, to this little bonus show that we're doing for those of you guys in the pre-lit community. So I wanted to introduce you to Attorney John Steinkamp and Crystal Stout. Ladies and gentlemen, how are y'all doing today?
We're doing great.
Yeah,
we're doing great.
Not the audience ladies, but my guest ladies and gentlemen.
Yeah,
I wasn't sure.
Me either.
That's right. So you guys are members of the community here, and Crystal and I were talking a couple weeks ago, and John, I had actually never heard of you, which I guess is not unsurprising because there's like a gajillion attorneys out there. But Crystal and I were chatting, and I got to talk with you, John, and the thing that we like to do here in the pre-lit community is kind of bridge that gap between CROs and consumer protection attorneys. And John, so you've been doing CRO or consumer protection law for quite some time. And Crystal, you're a paralegal with John, and you're kind of the guru that makes all of the documents come together. So without any further ado, tell us a little bit about your practice yourselves, and then we'll get into kind of some juicy stories and stuff that the audience would love to hear.
Sure. As I say, I've got a great story that just happened, so I can't wait to dive into this. But anyway, my name is John Steinkamp. I'm an attorney in Indianapolis, Indiana. I've been doing consumer protection work for about 13 years now, and my practice is basically suing debt collectors, especially when it comes to credit reporting issues and the violation of the FDCPA. And then also Fair Credit Reporting Act work. And not only do we look at trade lines when those are messed up, and we try to help the clients get those corrected. And if they don't get corrected, we sue. And then, of course, we look at impermissible pulls, those instances where typically a creditor or a debt collector is accessing a client's credit report when they don't have the legal right to do so.
So permissible purpose type things, basically.
Yes.
Very cool.
I'll let Crystal introduce herself.
Go ahead, Crystal. Tell us.
I'm kind of.
Why does the world know you?
Okay, so Crystal has worked for me for a very long time, and about 5 or 6 years ago, she was coming back from maternity leave, and I told her how I really wanted to jumpstart the Fair Credit Reporting Act part of my practice and get that really going. And so I kind of gave it to her, and then at the time she was working part-time because she had little ones at home, and she really took off with this, and then the rest is history. And now all these cases behind us, those are all active FCRA cases. And if you could see more, there's a zillion of them here. So Crystal has really just taken the handoff and she's run with this.
So, okay, well, you said when y'all first met, you were wanting to kind of kickstart and launch your FCRA side of your business. I mean, what were you doing before that?
Oh, it was, I do consumer bankruptcy work, and then, like I said, I sue debt collectors.
Okay.
As you can imagine, bankruptcy and suing debt collectors kind of goes hand in hand, because the client comes in for a bankruptcy case and says, oh, this debt collector is the reason why I called. I'm in here because, they were calling me and telling me that they're going to pick up the phone and garnish my wages tomorrow.
Gotcha. Okay. So you were doing more on the debt side with bankruptcy, FDCPA, and then you wanted to add in kind of the FCRA credit reporting side of things, kind of the natural progression, so to speak. Yeah. So, all right. So fast forward. I mean, how has that worked out for you? How do they tie together? And how has that benefited your firm and your ability to help the clients with more?
Well, it's one thing to sue the debt collector before the bankruptcy and put some money in the client's pocket, and everybody's happy with that. But it's a whole nother thing to get the client's credit reports after the bankruptcy is over with, and to look to make sure they're getting the fresh start they're entitled to, that their credit reports are clean and correct. And when there's an error, then the client is eternally grateful. Like, oh, my attorney found this error in my credit report after the bankruptcy was over with. And so they're ecstatic that we're going the extra mile to look at their credit report to make sure that their credit reports are clean and correct. And then Crystal found, she's found a couple of high dollar cases. Most recently, it was a couple that got $34,000 from one of their FCRA claims. As you can imagine, they were beyond ecstatic. And then our great story is we had a young woman. She was in her early 20s, and we had helped her with her bankruptcy case. Found a lawsuit, a violation of the FCRA on her credit reports post bankruptcy, and then sued. And I think she got $13,000 or so. And she came and picked up that check on Friday, and she was just beaming. And she was talking a mile a minute. She was so excited about getting this money. And I remember after she left telling Crystal, that money's gone by Monday. She's going to have one hell of a weekend with that money.
That's right. There's no recession going on this weekend with her. She is contributing to the economy. So, well, but that is really cool as a bankruptcy attorney that you're looking at the credit report and that you figured out that there's potential money for you. I mean, hate to say it that way, but that's what it comes down to. I mean, the violations equate to money for you, but helping the client, I think that's something that a lot of bankruptcy attorneys leave on the table. They just don't realize or appreciate or understand that it could be another vertical for their business. What got you inspired to go from the debt side to wanting to look at the credit reporting initially?
Well, as you said, it's kind of a natural progression, and I agree with that. And so we kind of went that way. I had been to a number of conferences on the Fair Credit Reporting Act, and so I was much more confident with it than I was, let's say, 10 years ago. I mean, I knew about the act and stuff like that, but I really wasn't using it for my clients' benefit. But I got to tell you, yeah, so it's helping clients. But let's face it, good business is often doing the right thing is often good business. So helping the client go in the extra step to get the client's credit reports, review them, make sure they're correct. And then, the young woman I just mentioned that had the crazy weekend with the $13,000 or $14,000 that she got, I would assume that she probably told a number of people, my bankruptcy attorney got me this money. And think of how great marketing that is. When people are like, your bankruptcy attorney got you $14,000 because of an error in your credit report? What's his name again? So right. Yeah. I will tell you that probably half the people who come in through my doors mention that either I got their friend or family member money from a lawsuit.
Yeah. So now, we've got a lot of credit repair owners who are watching this and who will be watching this. I mean, we certainly have some consumers, but a lot of CROs, and I mean, their primary goal is to improve credit. But, from your perspective, do you have clients who come to you and they may not really qualify for bankruptcy? Maybe they've got too many assets or their income, they fail the means test. You'd have to force them into a Chapter 13 instead of a 7. Like, is using the FDCPA and the FCRA, is that a strategy that you employ, like in lieu of bankruptcy? Like, okay, let's just try to use the violation potential of these other laws to get leverage against creditors to maybe settle debts, or is that an approach that you don't really take personally?
Well, once in a while, I will have a client who comes in, and typically they've been sued, and that's what has brought them to my office. But at the end of the day, they just don't have that much debt. So, and that's when I tell them, hey, look, maybe you want to consider other factors. Maybe we will, if I see something weird on the credit report, maybe it turns into an FDCPA claim, or, they're being sued by a debt buyer, and it's easy to defend debt buyer lawsuits. So, yeah, so it is possible to use the FDCPA and the FCRA and any other consumer protection statute to the client's benefit. And the great thing is, because the vast majority of my money comes from lawsuits, I can honestly tell my paying clients, hey, look, bankruptcy is not in your best interest. You need to go see a CRO, because there is this in your credit report, but you're not a good candidate for bankruptcy. Last year, my total gross revenue, 74% of the revenue came from lawsuits against creditors and credit reporting agencies and debt collectors. And the other 26% came from paying clients.
Yeah.
So yeah, if I tell a client, hey, look, bankruptcy is not in your best interest, well, I'm not really losing money.
John, when Congress created those consumer protection statutes, and they created it to where the winning party gets paid attorney's fees, they've thought of John Steinkamp. They're like, there's going to be this guy 50 years in the future, and he's going to make 74% of his revenue off of this statutory construction. So, but let's talk about that real quick for those folks watching who may not really understand that, or who may be new to this industry or just trying to figure out what's going on. So, there's different types of lawyers out there. You've got like the big, amazing, like white collar, like represent the big businesses. They have more money than God. And then there's the poor schmuck like you, John. You like to represent poor people, but we're just joking. But the consumer protection attorneys, you're kind of like criminal defense attorneys. You're usually dealing with people who don't have a lot of money, right? And so,
Correct.
Help little guy.
Yep.
but the consumer protection laws, so Congress, so FCRA, FDCPA, I'm sure some of the other ones, you can probably name them all, that they were constructed. So Congress wanted to like level the playing field between the consumer and these big institutional industries, debt collection, credit reporting. And so the way they design the laws is it says, okay, if there's a violation, winning party gets paid attorney's fees by the losing party. And it was designed to be able to enable consumers that don't have a lot of access to resources to find an attorney like you who's comfortable with your profession to say, okay, you know what, I feel like I've got a pretty good chance of winning, and I'm not going to charge you $400 an hour. I'll take you on like contingency, right? That's the general gist of kind of how Congress designed it. Is that right, John?
You are absolutely correct. The idea is to make it lucrative for attorneys to take these cases. And so the other side has to pay my attorney's fees as if I'm a paying client. And so if these cases go all the way to a courtroom, then I have to provide the judge with my itemization of attorney's fees and costs. And when I do have cases that go the distance, then my attorney's fees are $60,000-$70,000 in the case.
Yeah.
So
well, let's see. We've got Robert Sigmund. I don't know if you guys know Robert. He's got a company called Kredzu, tries to help companies get compliant with TSR and provides escrow for CROs. Robert, I just want to be clear, sir. I did not praise the government. I praised Congress. Okay. I praised the legislative branch, not our actual government institution per se.
Okay.
But there we go, Robert. So there we go. But it's every once in a while our Congress will slip up and make a good thing for the people, and giving you the ability to represent. Look, like pretty much you need to lift yourself up, guys. This thing is covering your faces up. You sit up on phone books. Okay, let's see. We've got Jason Oswald. What do you think about these people pretending to be attorneys or giving advice like the bureau bullies and people like, okay, I don't even know who these people are. I got to be honest with you. I don't know who any of these people are. And I'm not just saying that because
representing, acting as if they're an attorney when they're not.
Right. I think that people who are not attorneys and give legal advice, that's a felony in most states. So
so I don't. Jason, good question. I really don't know who these people are. Maybe I should. I don't know. But I mean, forgetting about who these people are. If somebody's pretending to be an attorney, then they're obviously retarded and asking for somebody to go ahead, John.
Whatever profession you're in, you should comply with the law, right? And believe it or not, us attorneys have rules of ethics that we have to follow, and I comply with the rules of ethics, and I'm very careful about that. And when there's a potential issue, then I stop everything and I go look to see, is this ethical? And I think we should all do that.
Check out the stuff they're teaching on lines of the straw man stuff. So here's what I would say. There's all sorts of things that people teach or whatever. I mean, and I am a free market, a libertarian capitalist. You go out there and you just do your thing to the extent to where you can't do it anymore. Now, if that means somebody's practicing unlicensed law and they get shut down, well, then so be it. I mean, that's the core issue, I think, really, Jace. I mean, you could say maybe you like or don't like what they're teaching, but let's talk a little bit about unlicensed practice of law as it relates to CROs. So, Jason, I'm gonna go ahead and extract that from what you posted up here, because like the unlicensed practice of law, I mean, it's it's kind of a gray area in all the states. A lot of states have these little committees for unlicensed practice of law where like somebody can file a complaint, and you got a bunch of gurus up there that sit on their pedestals and they make some sort of a decision as to whether they believe you unlicensed practice law based on their committee and getting together and whatever. But let's talk about that, right? Because like, I mean, you can operate credit repair and you can help people and do it totally legitimately and like, or you can like pretend that you're a lawyer, which is really not what you're supposed to be, right? So like, as an example, one thing that I teach is you want to just stick to the facts. And my fact is not to make a legal conclusion, to say, you violated the law or any of that. My job is to say, well, there's an industry standard known as Metro 2 that governs how this stuff is supposed to report. Your credit reporting does not conform, it's inaccurate. Your information is inaccurate for the following reasons, right? If we can stick to the facts, because it's like, you're not going to, one of the folks in our community, there was a thread going on a couple of weeks ago about, I guess, unlicensed practice of law. And he was like, yeah, I mean, you're not gonna call the plumber up and start citing all like the code to him and stuff. You're gonna call the plumber to fix your pipes, right? So, I mean, as a credit repair company, they come to us to fix their credit, and our job is to point out the errors, not to, make legal conclusions and stuff. And so, I mean, obviously it's a subjective thing. I'm not sitting here saying it's like black and white because it is a gray area. But what are your thoughts on, I mean, kind of where that line would be maybe for CROs, from your perspective of, well, this definitely crosses the line versus this is just passionate, but they're helping people and they're legit.
Yeah. So I will tell you, I'm not an expert in the rules of ethics. That's a lie. When there's an ethical issue, I stop everything and go do my research. And I'm certainly not an expert in the unlawful or unlicensed practice of law. I think that what I encourage everybody to do would be to read and know the CRO statute. It's a federal statute, and then whatever state you're in, review those state laws, if any, regarding the practice of law and or organizations. I'm sure there's probably some states that have their own CRO statutes, maybe California or New York or Florida. Those are the three that popped to my head. But otherwise, it's, one thing that, you've got to keep in the back of your mind. There's rules that we all have to abide by, whether we like it or not. And so
now you're up in Indiana, is that right?
Yes.
Yep.
All right. So which states are you directly licensed in?
Oh, just Indiana. However, I work with attorneys in other states, and then I will send them potential cases and say, hey, tell me what you think. I think this is a case in your state, but obviously I'm not licensed in Wisconsin or California or whatever. I do work with attorneys in those states, and they make the final call.
So I mean, do you have like a network in all 50 states? Are there some states that you don't really have a network in? What would you say?
Yeah.
Hawaii.
Alaska and Hawaii, we don't. But if I were pushed, I'm sure I could find an attorney in Alaska or Hawaii if I had to. But I work with a lot of attorneys around the country. I've been doing this long enough.
I know who have been looking for Washington State. You have somebody in Washington State? We could. I've got a hot potato referral for you when we get off this live, right?
All right. Yeah, sure. But yeah, so I've spoken at conferences for lawyers, and I've been doing that for the last 8 or 9 years. And so it is common for somebody who saw me speak to call up and say, hey, Steinkamp, I saw you speak last year at the FDCPA conference. I've got a debt collection issue. What do you think of this or that? And so, every day I talk to attorneys from around the country. Even yesterday, I was talking to an attorney in Wisconsin.
Yeah, I mean, that's what it's all about is having that network. Let's see, and Jason, you're plugging back in here. My issue is the negative impact they're making on the industry. Yeah, I mean, you're going to have that. I mean, that, all we can do is try to put out good information, have lives with amazing paralegals and lawyers, I mean, that's why. So Jason, I appreciate you watching. That was really when Matt and I started this community group in January of 2020, we wanted to just put out new information that you couldn't really get elsewhere, right? So, Jason, I appreciate you hanging close to the campfire, and Crystal, I appreciate you beating me up. You kept on like first you chatted with me on Facebook like a month or two ago, and then like it died out, like it got buried, and then you resurrected the chat. You were like, hey, I'm like, oh my goodness, like we were chatting, and then we put this live together, man. So there you go, persistency. So all right, so John, let's talk a little about these bankruptcy FCRA claims. So when you raise these claims, are you raising them in bankruptcy court, or are you going, regular? Are you doing like a new claim, a new case for FCRA
Okay.
related to the bankruptcy, or are you doing it in the bankruptcy court post discharge and opening it back up and saying, look, these people violated the discharge and the automatic stay and whatever because they're jacking up this guy's credit? How do you generally? What's the process with when you're dealing with bankrupt clients with post discharge FCRA claims?
I'm impressed that you know the lingo.
Well,
everybody brings up
don't compliment me too much. People watching may actually learn that I actually know what I'm talking about. All right.
So, most of the claims that Crystal finds are post bankruptcy. Clients filed bankruptcy, received their discharge. We pull the credit reports about 6 months later. We find the error in the trade line. We find what's called an impermissible pull, where someone accessed the credit report when they shouldn't have. Once in a while, there may be a claim pre-bankruptcy. And then if there is a claim pre-bankruptcy, we absolutely must list that on the bankruptcy petition as a potential asset. And that if you don't, the claim is lost forever. So we are very careful to make sure that anything found pre-bankruptcy is listed. And then the trustee has the right to take that claim if it's a Chapter 7, if it's a Chapter 13. Then down the road, the debtor gets to file that case and probably share some of the proceeds with the Chapter 13 trustee. But otherwise, yeah, most of the time it's post-bankruptcy. And there are times where we get the credit report 6 months later, review it, everything looks good. Or maybe we did find some cases, and then we calendar out another 6 to 12 months to review the credit reports again, because we might find more claims down the road.
So it's typically a fresh complaint that you're filing. I mean, it's you're not kind of going back and reopening the bankruptcy case or anything. Now, yeah, I mean, and then as far as because the CROs, the CRAs, the bureaus, we'll call them that. They're never going to be a party to the bankruptcy, right? So, but I mean, they're obviously a party to the post-discharge nefarious reporting. So I guess, I mean, typically you'll pull in the furnisher and the bureaus all together when you see errors. Is that typically how you'll do it?
Right. So we find the error on the credit report, call the client in, go over the credit report with the client, and then we work with the client in terms of drafting the dispute letters to the credit reporting agencies, the bureaus.
Yeah.
And then, and this is the toughest part, you got to hammer it home to the client to watch their mail for the dispute results and hope to hell that they don't throw them away.
Right.
And so,
exactly.
Can you bring up your POA method for this? Would you mind explaining that?
You just sending dispute letters using a power of attorney?
Yeah.
You know what? You brought it up, Crystal. I'll let you bring it up since you just did. Let's talk about that. What do you want to talk about? Let's bring it up.
I kind of want to understand the process that you actually do to be able to do that for the client.
Yeah, sure. I mean, so, and again, a lot of you who are watching, who have been around long enough know that, another one of the things, typically I talk about three things. One is Metro 2 is the industry standard for accuracy. And because the law requires reasonable procedures to assure maximum possible accuracy, that basically ties it right there to their industry standard. We also talk about how you can dispute directly with furnishers. And then the third thing is stepping out of the shadows, using a POA. So yeah, Crystal, thanks for bringing that up. I mean, basically, what I do is I get a notarized power of attorney from the clients, and everything we send out is on our letterhead. And I am not like purporting to be an attorney or anything, but you can get a power of attorney, which is totally different than an attorney at law, but power of attorney gives you the ability to step in somebody's footsteps, shoes, basically, essentially. And so we get the notarized POA, and then we'll send the dispute letters out to the bureaus and the furnishers. And a nice thing about that, especially for those of you watching, because there is this little carve out in FCRA furnisher direct dispute part that says a furnisher can ignore a dispute if they believe it came from or was prepared by a credit repair organization. Now, I think that's a huge slippery slope for the furnishers to exercise on that. But the point is if you've got a power of attorney, almost never will they kick that dispute. And if they do, well, just give the dispute back to your client. Then I'll have them turn into an affidavit, and then I'll mail the exact same letter back to the furnisher, but having it turned as an affidavit. And good luck to the furnisher that wants to kick an affidavit at that point, right? So, I mean, that little carve out is, well, it doesn't affect my business any. And, but the big part of it is, you want to know what you're talking about if you're going to use the POA, Crystal, obviously, right? And that's a big part also of kind of what we're preaching here and teaching people is, because it is tough to learn. John, you said, hey, you've gone to seminars and now your knowledge is a lot better than it was before. And you're an attorney. Imagine, a lot of folks start off as their own first clients in here. They don't know what's going on, but they're trying to get justice against these big giant beast companies. And then they tell their friends, their neighbors, and their brother and their sister. Next thing you know, they've got some clients. And that's how this industry really grows. And it is a huge learning curve. So yeah, Crystal, I mean, absolutely, we could use a power of attorney. CROs can do that. You can send things. It is absolute fake news that the bureaus want you to believe that you cannot have a representative send something to them. They try to make you believe that the consumer himself or herself has to sign off on the letter. And that's not even what the FCRA says. There's case laws with the good case laws spell out very clearly. And where that comes from is the FCRA in 1681I. It says that there's two ways basically that a consumer can dispute. They can either dispute directly with the consumer reporting agency, meaning they can lick the envelope and mail it directly to the bureaus, or they can dispute indirectly through a reseller, which means they can lick the envelope, mail it to the reseller, and then the reseller takes that and then forwards it to the bureaus, right? And the resellers are the companies. The resellers are the companies like the mortgage companies, the ones at the car dealership. So if you read it, John, I say you guys, if you read what the FCRA actually says, it says the consumer can dispute directly with the CRAs or indirectly through a reseller. There's nothing in there that defines consumer and limiting it to consumer. And in fact, the bureau's own documents that they send out say, literally their own documents say, this thing that has been going around for TransUnion the last year, where they keep on kicking disputes. But on that document, it says, we don't believe it's you, or, we'll prove that it's you or your legally authorized representative, right? The bureau's own correspondence, firsthand documentation say they will communicate with firsthand with legally authorized third parties. And so the problem credit repair companies typically run into is when they send these letters, they appear as though they come from the consumer. There is no power of attorney actually submitted to the bureaus. So that runs into a huge gray area, in my opinion, not really with FCRA, but just kind of the power of attorney requirements, I think, because if I get, this little piece of junk mail in the mail or whatever, this thing looks like it came from O'Brien garage door. I mean, it came from the mailer guy that mailed it, but maybe it came from somebody else, right? I mean, so I think there's certain POA issues where if you're sending things out and, because the POA is supposed to be submitted with that, and you're supposed to show yourself as being the agent. Let's talk a little about that, I guess, since you kind of raised it up. So we've got a number of issues here, John and Crystal. One is the FCRA, and then there's kind of the whole POA type fiduciary laws, which is a whole other set of laws, and weaving those two things together to help CRAs to get the most teeth possible. Thoughts on that, Crystal? I'll let you chime in since you raised the question. Go ahead.
Oh boy, I don't want to pretend like I know the law on that. I honestly have no idea what the POA laws are. I was actually just kind of curious of how you're able to do that for the credit, like as for the consumer. I was curious how you're able to do that exactly, and I guess honestly, just to see if there's a way we could utilize it for our clients, if maybe we could get the mail faster.
Yeah. Steve, first I've got to compliment you on your ability to cite to the FCRA.
Beyond John, please. In addition to making my head go big, you're going to make the audience actually think that I'm actually qualified to be hosting this. We don't want the haters and the naysayers out there to actually think that I know what I'm talking about. No, seriously, thank you, John. I appreciate that.
Besides S2B and EV, I can't tell you. I don't know if I can cite two other parts of the FCRA statute. So well done. But on this whole thing of power of attorney versus, who do we want to have send the letter? I think that's one of those things that, should the letter come from the power of attorney person, CRO, or should it come from the client himself or herself? I think that's something you determine on a case-by-case basis. If it's something that it's a minor violation and you as a CRO are confident you can get this corrected for the client quick and easy, great, do that. Because chances are the client just wants their credit report corrected and move on with their lives. They would see this as just unnecessary issue they have to contend with in their otherwise busy lives. However, on the other side of things, I think you're doing the client a disservice if the client has a serious error in the credit report. Let's say the mortgage company is totally screwing up what is being reported, and the client's trying to refinance their house, and for whatever reason, because of this mistake, they can't get it refinanced. Well, you'd be crazy to try to correct it yourself, and instead send it, do the disputes to set it up for a lawsuit, because if the client gets denied a refinance of their house, that's worth a ton of money to that client. And here's an easy story, or a quick, easy story. I had a Chapter 13 client about 5 years ago or so, and he finished his Chapter 13, paid the money back he was supposed to pay back, and immediately after he got his discharge in his Chapter 13, he went to refinance his house, and he was going to he's going to save a couple of percentage points, but he got denied because the mortgage company had shown that this debt was wiped away in the bankruptcy, which was not accurate at all. He kept his house in the bankruptcy. So we sent dispute letters to the mortgage company and the credit reporting agencies. None of them changed it. So now I sent him back to get looking to getting refinanced, and he was able to get refinanced. But according to the email from the loan officer, if he would have had a correct credit report, he would have gotten a 1% lower interest rate. Well, 1% on a $150,000 house is a fair amount of money, especially over 30 years. And so right away, I've got this great claim where my client made tens of thousands of dollars because of this mistake on his credit report. And so that's an easy way that you're preserving that client's claim to money that's rightfully they should get. So again, I think it's case by case. If it's something where quick and easy, do it. But if it's something where you can preserve the client's rights and set them up for a great recovery, by all means do that. Because you know what? If you're the CRO that identifies this and sends them off to an attorney, not only is that attorney going to send you business, but that client's going to remember you as well and tell all their friends about you.
When they're out spending $13,000 on Chanel purses and stuff over the weekend, right, John? You'd mentioned something that is worthy of going back to. You said the loan officer wrote basically an email or a letter just stating the damages. It cost them a point. And we do a show. I do a show in this group, a regular show with a guy named Doug Miner, who is an expert witness, an FCRA expert witness. He's been in like hundreds of lawsuits, I think. He doesn't like to say that. He's a humble guy. But anyway, that's what we talk about. And for the CROs listening, I mean, it's an important point because, we need to think like that. Like, and especially, I mean, the bureaus, they're only going to do what they're going to do. But on the furnisher side, especially if you can, it's a little bit easier to compel the deletion from the furnisher as a CRO, in my opinion. I mean, the bureaus, it's just totally like just luck of the draw. What do you get them to do? And I mean, you're not going to call them and get them to do anything. They really only respond to either do they push the button or do you sue them? I mean, that's my experience with the bureaus. But the furnishers, I mean, if you can demonstrate to them, hey, Wells Fargo home mortgage, as an example, whatever, hypothetically, this is wrong and my client's being damaged by it. If you can get a supervisor on the phone or one of their compliance officers, again, you can't do this if you don't have the power of attorney, though, right, Crystal? And so this is where having a POA enables, an average person like those of us watching this to get that POA and then to be able to provide a higher level of service, right? And it may not be right for all CROs. Maybe some CROs can have like the white glove, like treatment program, okay, this one's going to be like concierge, right? If you want to charge, it could be a value add product potentially, maybe that some CROs have or whatever. I just do the same for all. I mean, I just get the POA from everybody because that's just how I've done it like forever. So Crystal, let's talk a little bit about you now, because you are the one who actually, John, you make John look good, right? Because you're the one who puts those letters together.
I would agree with that.
John's impressing us with all the legal stuff, but you know what? He's nothing without you putting those letters together. Is that fair to say, John?
Yes.
All right. So Crystal, let's talk. And this is what our viewers can really relate to, right? Because this is what our job is to look at credit reports, hopefully, and find errors, not to like just send like a not mine, never late every time, or approve it or remove it. But so what are you looking for when, because you're coming from the perspective of a paralegal for a law firm, you're not really a CRO. I mean, so you're not, you don't have everybody with bad credit from the mortgage getting referred to you. You kind of have people coming, I guess, that are more aligned with like needing legal services. So, what are you looking for when you're putting those dispute letters together for the firm?
Oh, so I actually look at the credit report as a whole, and anything that's technically wrong with the report at that time, I include it with it. Maybe it's a bad spelling of a name. Maybe it's a duplicate date of birth. Mm-hmm. Basically, you confirm some information with the client on the phone, and if they're like, yeah, I don't know what that is, or something like that, you just add it to it. So it's basically just a blanket dispute that's, that they're to help them, ideally.
Yeah, and then as far as the trade lines, so let's talk a little bit about kind of what your firm's strategy is for that. I mean, I will audit all the data in the trade lines, and if there's inconsistencies between the bureaus, I'm putting all that in a letter. And I'm putting the data from all three bureaus for that data field. So whether it's the balance, the date open, the date closed, the date of first delinquency, the who cares, whatever field. If it's inconsistent among the bureaus, I'm going to point that out and send that to the three bureaus. And I'm going to be like, look, it's your industry standard. It's your data. It's your requirement to report maximum accuracy. Which one of you is giving me the industry standard accurate report? And they never really do fix it, right? So, I mean, when it comes, so you mentioned things like personal identifying information, addresses. When it comes to the trade lines, like I know, John, you were talking earlier, okay, I mean, if it's a post-discharge, I mean, that's kind of easy to point out. But, are you guys looking at just technical, I hate to use the word technical errors, John and Crystal, because everything is
anything that's wrong, anything that could be wrong, or anything that's not theirs, anything that's
well, you could call it technical, but one of the things that we look at are impermissible pulls.
Yeah.
That's where a person files bankruptcy on Citibank, and then 6 months later, Citibank is accessing that person's credit report, and it doesn't necessarily harm the person's credit score, and Citibank probably won't do anything with that information. But you know what? It's still illegal. It's still an invasion of that client's privacy. What if somebody went through your house and went through all your finances and then left? Well, you'd still feel like well, that's weird that somebody went into my house and went through all my my checkbook and my other finances. They didn't do anything, but they shouldn't have been there. That's just
John,
wrong.
I'm gonna pause you right there actually, because
Yeah.
you the way that you just articulated that, really, I've got to ask you a question. So a lot of FCRA attorneys, and kind of the common theme of the way that the wind is blowing with the FCRA and the case laws, is that you've got to be able to show damages. Judges want to see damages, and you just literally said, well, you know what? It's still illegal, and they invaded their privacy. Well, that's exactly how the FCRA was actually designed like 50 years ago. But unfortunately, with case laws, I mean, well, if it's just illegal, the judges don't really seem to care as much unless you can prove that they were damaged. So do you find that now, usually we're talking like trade line disputes, and stuff like that. Permissible purpose, obviously, is an entirely different section of the FCRA, 1681B, John, just to impress you with my knowledge there. But it's an entirely different section of the statute. But do you find that there is like a difference in damage requirement, whether you're disputing trade lines versus permissible purpose? What's your perspective on that?
All right, so it depends on the nature of the claim. The impermissible pull, as I just mentioned, that is a viable claim. The Seventh Circuit Federal Court of Appeals came out with a case called Persinger versus Southwest Credit that said that it's an invasion of somebody's financial privacy if you access their credit report when you don't have the right to do so. So that's a viable claim that has standing under the United States Constitution. With trade line errors, it's going to be a little bit different. I think it's much easier to have standing and a viable claim with a trade line error. So yeah, I think it just depends on the type of case. And with the trade line, there's a greater chance of actual damages, that the person's been denied credit because of this error in the credit report, or the person was able to get credit but a higher interest rate. These are all places that somebody's been wronged financially. And then you're going to have plenty of cases where trade line situations where maybe the actual damages aren't as obvious, but then there's statutory damages that someone can get under the Fair Credit Reporting Act as well. And I think Crystal had something.
Yeah, I like how he can tell when I just want to say something. So basically, what I would want to add to that is that if it's an impermissible pull, the damage is the fact that it was an invasion of their privacy. Mm-hmm. If it's a trade line violation,
thank you.
So someone has to have seen that error. If someone's seen that error and you've been denied, that's different than, hey, I'm just pulling my own report and this is wrong.
And so, but someone seeing it could be somebody who accessed the credit report for marketing purposes or any other legal reason.
I guess say you get a bill in the mail. I'm pointing at my stack over here. But say we get a bill in the mail and it says that specifically from a company. It says you qualify for a $70,000 pre-qualify for a $70,000 loan. Well, I don't know about you, but if I actually owe $70,000 in debt, I'm curious how they got that information.
Yep.
How do they know this about me? Did I authorize you to pull my stuff?
Right.
Well, your stuff. See if that's the case.
So let's back this Mack truck up again a little bit and what you guys were saying. So we've talked about invasion of privacy on the permissible pull issues, and then really defamation, or did somebody see the report on the trade line? And so let's kind of hone that in for our viewers, right? Because prior to FCRA, there was no FCRA. Can you believe, John? I literally just said that prior to FCRA, there was no FCRA. Prior to FCRA, there was no FCRA, right? So what remedies were available to the consumers? Well, it was just kind of your common law claims of negligence, defamation, invasion of privacy, right? And the FCRA kind of stripped away the consumer's ability to use those claims unless you can argue malice or willful intent. But then it created all the mechanisms that, to your point, John, it's illegal. If they don't follow the mechanism, they should be able, even without proving damages, technically to say, well, they didn't reinvestigate, or they threw my thing in the garbage can, or they didn't fix it. Congress said, okay, you can't sue for defamation or invasion of privacy, but you can sue if they don't undergo the mechanism properly. But so now what you're saying, though, is like, okay, let's, for our audience to understand, the trade lines, there's really no invasion of privacy per se, unless, and there's no defamation, because you have to prove a third party saw that. So then it's really just like, okay, I may not like it. Like if I were to go to you, John, and talk a whole bunch of smack to you and to you only, to your face, that's completely false, you can't really sue me for defamation because nobody else heard it. But then if I go and I publish it to the world, so for those of guys who are kind of watching, CROs who are watching, when you have a consumer disclosure like the annual credit report or something like that, that's published directly to the consumer from the Bureau. That has not been published to a third party. So what you're saying is it's important that you can demonstrate that inaccurate information was published and a third party saw it, such as a mortgage company, a car dealership, a credit card company. And then with that, that's when you're saying, okay, this was basically kind of, you can't really argue defamation, but you say, well, you violated the FCRA, you didn't correct it, and I was damaged because, even though I was defamed, but I was damaged because it cost me 2 points of interest or something like that. So that's the publishing of information to third parties that's going to damage you. Whereas you're saying, to your example of them going in and opening the front door, when it's an impermissible purpose, well, there's really no defamation there, but there's invasion of privacy. And the negligence, defamation, and invasion of privacy were kind of the three core issues that Congress was trying to address. So it's interesting. So yes, I can see now where you're saying, okay, you know what, if there's an impermissible purpose, it's like they've kicked in the front door and broke in. And so, I mean, you're not going to like necessarily sue for invasion of privacy, but negligent or willful noncompliance, right, under the FCRA. And then you'll tell the judge, well, judge, they were negligent or willful. How can we prove damages because they invaded our privacy? So I definitely kind of get what you're saying there. Hopefully that makes some sense to our audience. We've got a question coming in here from Yassine. What's the name of that case? Okay, I think you had cited a case, John, that
Persinger, Persinger versus Southwest Credit Systems.
I'm going to publish that up here, Southwest Credit. Persinger versus Southwest Credit. Okay, I'm just going to post that up here. So boom, Persinger versus Southwest Credit. Okay, all right, sweet. So okay, so so you do a lot of these impermissible purpose. Do you do more impermissible purpose than trade line errors, or like 50-50? I mean, what would you say?
Not lately.
So all right,
way more trade line errors.
Yeah.
All right, let's talk about the frame up for the trade line error disputes. I think
actually, I want to stay with impermissible pulls just for a minute.
Yeah, go ahead, John.
Because this just happened. I'm very excited about this. I had a client call in, and he's been with his employer for 6 months, and he checked his credit. He's trying to buy a car over the weekend, and saw in his credit report that his employer accessed his credit report last week. So he calls me up and says, well, Mr. Steinkamp, I don't think I gave them permission to access my credit report. And if I did, why are they doing it now? Why wouldn't they have done that before they hired me to make sure that I'm okay guy? And so I was like, well, that's an interesting thought. And so I told him to go get all the documents from his HR department or his HR file, and let's see if he did give them written permission to access his credit reports. And if he didn't, then he's going to have one heck of a class action case. Crystal's already going like this with her hands, because this is a huge corporation with offices in 6 or 7 states. And my client said that there's thousands and thousands of people who work there. Presumably, this company is getting all their employees' credit reports, and if they don't have the right to do so, this is going to be one fantastic class action case. So,
Right.
something to keep in mind.
Brian Ponder, another fellow FCRA attorney, says go get them.
Yes, I saw
Yeah,
that.
I also wanted to add, so keep in mind, this goes for people that have like a landlord, right? If
Oh
they
yeah.
if you never authorize them to pull your credit report, they have no right.
Crystal, you tell it how it is. That's right. You have no right. That's right.
So,
They don't have a right.
so I thought,
I can imagine these dispute letters you're drafting. You're just like, you have no right to pull my credit. What's wrong with you? Your ass is put on notice.
Can you tell I was just talking to somebody in Georgia a little bit ago?
Yeah, you don't have no right to be accessing my client's credit report. We're going to sue your ass, right? All right.
but Crystal brought up a good point. So landlords in particular are horrible about getting people's credit reports when they don't have permission to do so. I've had multiple cases where a person was not on the lease, but they didn't sign under the lease. They were just an occupant of the apartment, and then they leave the apartment complex. They check their credit report, and that landlord or apartment complex accessed their credit report, even though they had absolutely no right to do so. So that was a case a few years ago. And then many years ago, about 5 or 6 years ago, and Mr. Ponder brings up a good point. Many landlords fail to give adverse action letters too. That's absolutely correct.
Unfortunately, there's no private right of enforcement against that.
So, but landlord-tenant law, or the landlord-tenant transaction, is not credit as that term is defined under the FCRA. So landlords in general, even when they're trying to collect, or they're debt collectors, when they're trying to collect this old debt from when my client broke the lease, or there's leftover money that's owed after the lease is over with, they can't be accessing the credit report unless they got written authorization to do so.
Right.
So in a case called PIG versus FCO is Fair Credit Outsourcing, the court found in my client's favor and said that FCO, who accessed my client's credit report in trying to collect the debt, couldn't do so legally because they didn't have written authorization, and the landlord-tenant transaction is not a transaction as credit under the definition of credit. And this would also apply to gyms like LA Fitness or Gold's Gyms or things like that. If those companies or their debt collectors are looking at people's credit reports, chances are that's a violation, unless, of course, they've got prior written authorization. But those would all be, I think, good cases.
Good stuff. This is a good conversation because it's a little different than the typical credit repair conversation. Because, I mean, a lot of credit repair companies aren't really looking at inquiries from the permissible purpose perspective. But from a legal perspective, that is definitely freaking ground zero target right there. Okay, so we've got Lawrence. He's asking, is it illegal and a cause for a suit for a creditor to keep reporting a charge-off account as if it's an active account? So, well, Lawrence, I'd have to say we'd want to take a look at the report and see how it's reporting, because it's not necessarily an issue for them to report every month that is a charge-off account, because if it's got a balance, the status of it every month is charge-off with a balance, and they're supposed to report that every month. So, I mean, if you're looking at the payment history and it's showing charge-off, and there's a balance, I mean, that's actually accurate reporting because they're supposed to timely report on a monthly basis. If it's a paid charge-off, there's probably no need for them to continue to keep on reporting it, because it would be in a final status. It would be paid closed. There's no more status for it to continue to report on. So I'd say, from my perspective, I'd want to see the report and see exactly kind of what it is you're looking at. John and Crystal, what are your feedback on this question?
So what I'm thinking is I would double check when the account was actually supposed to be opened, and I would actually double check the date that's showing on each report. See if they're possibly re-aging it.
Yeah, so this actually, he just posted it right when you were saying date of last activities. So, but again, does it have a balance? Okay, date of last activity keeps changing. Does it have a balance? I mean, if it has a balance, they can report it every single month, because it is currently each month a charge off. If it has no balance, then there shouldn't be any activity. So let me know, Lawrence, if it has a balance or not. But John, what are your thoughts? Is this something that you have an opinion on, or are you just going to defer
I
to
agree with
Crystal?
Crystal's assessment. And
Yeah.
so,
All
so
right. Sweet. Let's see here. So there we go. All right. Yeah. So, well, interesting stuff. My goodness, hard to believe we've been chatting for almost an hour. I mean, I could keep on going if
I
you
know
guys want to, but I got a feeling you probably got money making things that you got to do with the rest of your time.
we can always
How
do another.
how can
Okay.
absolutely how can our audience get in touch with you guys if they wanted to reach out to you, John and Crystal?
So, yeah, they can call the office 317-780-8300. Or I don't know if you can put our email addresses on the screen.
Yes, I think not letting me post it in Facebook, but I can do on my YouTube. But let me post it up here on the screen. What is it? So it's John, right?
So it's Crystal at johnsteinkampandassociates.com.
All right. Let me
And
write
yes, it's all spelled out.
It's the world's longest email address. We're not happy about it.
John Steinkamp and Associates.
Yes.
.com. Okay, let's see. Crystal at John Steinkamp. Let's see.
I don't know if it fit on the screen.
Let's see here.
That's a good
All
one.
right. Hopefully we spelled that right. Crystal at John Steinkamp and Associates.com. Hopefully
That's
we
perfect.
figured that out. So let's see here. Another
Well done.
question coming in from Quan. Let's see here. Quan, going through a case where I used Truth in Lending Act, but apparently time barred. Yep, 1 year. Exactly. Down payment was misapplied. So I countered with fraud since there are no statute of limitations is sufficient. Well, I mean, I think it's I think it's been tough for you to say that they misapplied the payment. I mean, I guess what we're really trying to say, Quan, is just because the law isn't in your favor doesn't mean you can make the facts fit the law that you can find, right? I mean, it's going to be hard pressed to say, well, they misapplied the down payment. Was there really fraud, right? I mean, I think that's going to be a tough one to argue in front of the judge. Now, when you say they misapplied the down payment, my question on that is, what do you mean by that? Because, I mean, on the purchase agreement, and if it was financed on the sale agreement as well, the sale contract, I mean, it's going to show like $500 of down payment. So when you say, again, I'm assuming it's maybe, I mean, is it an automobile, Truth in Lending, or what, I guess what type of transaction is this? But
So yeah, and I don't know if fraud is a good way to go, because typically with fraud, you have to provide specifics up front in the complaint for damages. So I think that might make the fraud case that much more difficult. However, if the down payment is misapplied, you could argue negligence or something to that effect. That would have a 2-year statute of limitations. So as long as the statute of limitations isn't beyond 2 years.
Added to the total price, not deducted.
okay, so we have an
If
automobile.
it's still your money,
So Quan, if I'm understanding correctly, they okay. So you said it was added to the sale price, not deducted.
commission up
I
front.
mean, so there's not a line at all that has. There's not a line at all then that has a down payment. Sometimes dealers will inflate prices, but then also like inflate values of trade-ins and things like that. There's certain things they can do with the numbers where the math still comes out the same. But you're saying they took the down payment, they sold the car for more than what they were supposed to, and there is no line item for the down payment, and then the consumer evidently signed off and has been with that agreement. So what comes to mind also, John, let me know your thoughts. A lot of states have like deceptive trade practice consumer protection laws, like, and dealerships would definitely qualify for deceptive trade practices laws. Which state is this in, Quan? Check your state, see if there's a state level deceptive trade practice law, something like that. What are your thoughts on this? I mean, if the buyer's order is reflective, well, let me back up for a second, I guess, before I get back to John. So Quan, number one, my question is, how do you know that the sales price was inflated by the amount of the down payment? Like, do you have a buyer's order that had the original negotiated price, and then you have the buyer's order and the buyer's order is kind of like the pre-contract document that they sign, I mean, so how can you show that? Let's see, Florida, hit them with Okay, it looks like a Florida deceptive trade practices. Yeah, oh, that's what I would have done. John, what are your thoughts? So, I mean, it sounds like we've got a squirrely situation.
Well, I liked your idea of the UDAP laws, the Unfair and Deceptive Trade Practices Act.
Yeah.
Almost all car dealerships are going to fall within the scope of the state's UDAP laws. And I think almost every state has UDAP laws that can help the client. And typically the statute of limitations is going to be 2 years or more for those. There could be a UCC argument here. I don't know for sure, but that would be another place to look at. So yeah, I would, I think it's important to look at it from all directions.
If this is reporting, Quan, I mean, so you definitely want to help your client. I get that. You're definitely fully aware that there are statutes of limitations on certain things. If this is reporting on the credit, you can always make the argument that the credit reporting is inaccurate because it's not reflective of reality, even though the paper will show that it's reporting accurately. But then you could have some fresh causes of action under FCRA. Because I think, John, FCRA, you have 5 years, John, from the 5 years under FCRA for the time that you first find?
Yes, data discovery.
Yeah. So he could potentially, if this thing is reporting on the credit, let's see here, you threw the freaking kitchen sink at him, huh, Quan? So if you're trying to get actual legal leverage, the FCRA may be the mechanism for you to actually get something that's not time barred. Then the problem is you're going to have to be able to demonstrate that what's reporting on the credit report. It's probably going to match what's on the paperwork. So then you're going to have to be able to demonstrate that what's on the paperwork was actually not what it should be. John, John, this is actually a really good scenario, Quan. So John, let's assume that this consumer gave the dealership a down payment, and let's assume that this down payment was not recorded on this retail installment sale contract. Okay, let's just assume that this down payment vaporized and is nowhere in this transaction. And also, I guess that the sales price has been inflated, but that's not even really the issue. The issue is if they gave a down payment and it's not reflected in the sale contract. With the tools that we have here, would you agree that FCRA is probably the primary statute where it may not be time barred, and he could at least open up some sort of legal leverage? What are you thinking?
This is a personal case. Well, I think it's a good start. Again, I think you look at it from all angles and see where each angle leads you. I like the FCRA, and so.
So let's assume Quan came to you and he was like, John, I found you on this amazing podcast. You seem like a wonderful attorney, and I just happen to be in Indiana. But let's say it was the perfect, all the stars aligned. He's like, look, I put $5,000 down on this car, and it's not on my sale contract, and I just realized it. And so you guys dispute the FC. So let's talk about how you would take this fact pattern, because we know that what's on the credit report, if it's accurate, is going to match the paperwork. But the paperwork is not reflective of reality.
Right.
I mean, it's reality, but not really reality. So how would you take this if this fact pattern came to you? How would you use the FCRA and demonstrate that it's inaccurate, even though when they check it against the documents, it would validate that the reporting is inaccurate? How would you approach something like this?
You'd have to find evidence of the payment that was lost. So if that was done by debit card, get the bank statement showing the transaction date and the amount and everything like that. If it was done by check, get the canceled check. If it was done by money order, you can get the canceled money order from the bank. And you can also, in the lawsuit, require or make the car dealership turn over its records. If the car dealership had that money come in, well, there must be some sort of physical evidence of where that money went.
Or footage.
Yeah, or footage. Yeah, maybe there's closed circuit TV, and you could see the person swiping the card or whatever. So I would start.
Sales manager used it that weekend on blowing hookers, John. You know what I mean? Like, that's where the money went. 5 grand cash. We know where that's going in the car business. And I used to be in the car business, but so never mind. Whatever. Okay. All right. Here. So let's get focused again. So now you said evidence. Okay. Let's assume that for whatever reason, let's just say this was either a cash down or he's unable to get some sort of evidence like that. Would preparing an affidavit and attesting, hey, like this is actually what happened, and swearing off on that, like, I mean, obviously that is evidence, but would that be evidence that somebody like you would feel comfortable like pursuing if you can't actually prove the money transaction through means other than an affidavit?
Well, if the affidavit's all you got, then you got to go with that.
Yeah.
He should have himself and have an affidavit though.
Yeah.
Am I wrong?
No.
I don't think he should file a lawsuit himself though, and be the one on the affidavit.
Right. Yeah, that's a good point, Crystal. Look at you. That's why you are a paralegal, because you think like all the little ways that you can get trapped here. So.
So you can use the affidavit to get is no longer shut down.
So Quan, I'm going to buy you a Bible.
For that.
Quan, I'm going to mail you a Bible and just tell you to just start praying for better luck moving forward. How's that sound? I'm sorry, Quan.
Poor guy.
You can
always see if the owner though of the dealership owns another company.
Right. Do they own another company, or was there insurance in place at the time of the transaction? So car dealerships no longer in business, but there must have been an insurance policy. And so
let's see here. Look at this here. That happened to me, and the salesperson sent me some of my money back. Not all. I have text messages as proof. All right. Well, there we go. So they added gap. They added gap insurance. Okay. So they sound like a hot sticky mess, dude. Jesus Christ. So, all right, Quan. So let's get focused here. So you've obviously got something going on here, and that's what I like about you. By the way, Quan's in my training course, and he's got some really good cases. Quan does world-class disputes, by the way. If you guys haven't met him and you guys watch, and feel free to reach out to Quan. He actually reads the reports and puts the errors on the dispute letter. Can you guys believe that? That's what you're supposed to do. So I have no doubts that Quan is able to put together a really good dispute letter. So Quan, yeah, I would say reach out to John and Crystal afterwards if you need me to make a Facebook connection. I mean, obviously it sounds like you got something here. And, that's why they're here, is to make connections. And let's see if maybe they can help you through the process. So this is more than just a not mine, never late. This is they took my money, stole it, jammed the gap insurance on my contract, and decided to go out of business afterwards. So
I wonder how many people they did that to, though. So class?
Yeah, possible.
That's crazy. So there you go, Quan. So reach out if you want to reach out to me after, and also, I know, Quan, I think you've got that Shiva's arbitration course. You didn't mention arbitration. I wonder if there was an arbitration clause in this agreement. That would be interesting.
Almost certainly there was.
Yeah. So if there's an arbitration clause, I mean, how do you arbitrate, John, against a dealership that is no longer? Well, so let's talk about that real quick, Quan. So you said the dealership's no longer in business. Mm-hmm. Quan, was this a tote to note? Because who held the paper, right? Because if they sold the paper to a lender, that lender is still going to be that lender is on the hook for all the egregious violations of the dealership. That passes through the chain of ownership, right, John?
That's correct.
Yeah. So this case is in arbitration. Oh, sweet, you are arbitrating. You're holding them, dude. Quan doesn't play games with these people. Quan, keep us in the loop. Let us know, man. That is awesome. It sounds like you've already thought of everything. And John, if you need another paralegal, just hire Quan, because he really is.
Very nice.
All right, let's see here. So,
Santander. Oh, I hate Santander. They are awful.
So hold on, what did they do? Is that the company that did that? Well, wait, that wouldn't be the dealership.
So Santander now has the note, I assume.
Okay. So, it looks like the one that said this happened to me. This was from Tia. So this was another person posting this. So this isn't the same thing. We had another. Okay. Tia Love had this poor thing happen, but Santander. Well, there you go, Santander. All right. Well, that's how they roll, preying on poor people for 50 years. That's Santander. So hopefully you can beat them up on AAA. Was this thing a repo, by the way? Because Santander repo calculations, from what I understand, are always jacked up as well. So, Juan, if this thing was a repo, that might be something else to take a look at. John, this is what we call this the what do we call
Trifecta?
it? We call this the jackpot. Huh? We got a little bit of everything going on with this
Yeah.
particular case. My goodness
Yeah.
gracious. All right. So, all right. So again, as we kind of wrap it up, you guys can go. Let's post up your email address again up here. We can go to Crystal at johnsteinkampandassociates.com. Feel free to reach out to them. John and Crystal, I appreciate you guys making
Yeah.
the
Oh,
time to do this
thanks for
show.
having us.
Yeah,
Yeah,
thank
it's always a
you very
pleasure.
much.
You
It's
know,
a lot of fun.
we try to bring this content out to help those folks that are watching. And let's see here. He also had me. So this was the text message. This was Tia thinking service was included to find out I was charged for it. Yeah, I mean, yeah, car dealerships. I used to work for them. I know all the tricks, and they, dude. I mean, pretty much it's almost impossible for you not to find like a deceptive trade practice argument against these car dealers. You know what I mean? It's crazy. So. All right. Well, that being said, for those of you guys watching, thank you for joining. Feel free to reach out to Crystal and John. They are here to help. They're in Indiana, but they have a global, worldwide network of consumer protection attorneys. And we will see all of you guys on